We go on call to order prayer. We move to page 2. Apologies for absence. Welcome and opening remarks. Reading and confirmation of the minutes and matters arising. Deferred. We go to the consideration of the content of the bill, the presentation from the Ministry of Legal and Constitutional Affairs made by the Senior Director in the Constitutional Reform Division, Mr. Christopher Harper. If there is no correction to page 2, we go to page 3. In the second paragraph of page 3, revised laws of Jamaica, revised laws to be capitalized. The revised laws of Jamaica, that's a proper noun, and they refer to the consolidated provisions from the Acts of Parliament and the Principal Acts. And just to say, wherever Constitution appears, the Constitution is to be capitalized when it refers to the Constitution of Jamaica or Jamaica's Constitution. Third paragraph, there is no correction. Fourth paragraph, commencing Mr. Harper further explained. Next paragraph, following, as regards qualification. Then in relation to the procedure, if there is no other correction on page 3, we go to page 4. I would ask that in the second paragraph on page 4, Mr. Harper then provided details regarding the nomination process, stating that, please insert the word proposed, section 25. So between that and section, please insert the word proposed. We go to the paragraph commencing where the same nominee was referred for a second time. Next paragraph, if there is no correction. Next paragraph. Paragraph commencing concerning the President's removal from office. If there is no other correction to page 4, we go to page 5. If there is no correction to page 5, we go to page 6. So the Jamaica Constitution, the word constitution should be capitalized, as I indicated. I will not repeat the need to capitalize in respect of that word, but just ask the clerk to note that wherever it appears in context, it should be so capitalized. If there is no other correction to page 6, we go to page 7. The last sentence of the first paragraph, she added that the existing model had worked very well and there was no desire to change it at all. It really should read that there was no intention to change the model, but where there was a need to improve, then that would be considered. Madam CPC, drafting instructions are a specific, um, what is the word? Should drafting instructions be capitalized or they are okay as drafting instructions because it's a title of a particular document and a step in the process? May I seek your view on that?
No, it doesn't need to be capitalized, Chair. It's just
Okay,
an
thank
ordinary
you.
term.
Thank you. All right. If there are no corrections to page 7, we go to page 8. In the second paragraph, the chairman provided an exposition. Well, I would ask that it be corrected to say the chairman explained the difference between an act of parliament and the revised laws of Jamaica, not the actual laws of Jamaica. And Ms. Cohen, going forward, I ask that we try to make the sentences very short. So you see that sentence, first sentence in the second paragraph is going into 5 lines. All right, if there is no other correction to page 8, we go to page 9. May I suggest that we delete that being? The chairman then addressed the second goal of clause 2, of enabling the continuation in force of the Constitution. To be read and construed with the amendments in the bill. And I also ask that where possible, we use less words than more words to make it simple and easier for readers. All right, if there is no other correction to page 9, we go to page 10. The second sentence, I'm suggesting that it be revised to read, the chairperson, and just to say I have no difficulty with the use of the word chairman, informed the committee of a proposal to amend the Law Revision Act to include the clerk to the Houses of Parliament as a Law Revision Commissioner. All right, if there is no other correction to page 10, we go to page 11. The sentence which reads, Member Davis commented that it made one want to stand at attention. I suggest that it be revised to read. Member Davis commented that the reading of the preamble made her want to stand at attention. I think that was the point.
Exactly. She said we should be standing at attention.
Or that when the preamble is read, persons should stand at attention. That was the feeling she got. So Member Davis commented on listening to the preamble being read that it made one want to stand at attention. If there is no other correction to page 11, we go to page 12. Right, if there is no correction to page 12, we go to page 13. If there is no other correction to page 13, we go to page 14. All right, if there is no correction to page 14, will someone move for the confirmation of the minutes as corrected?
I so move, Madam Chair.
Thank you, Member Sinclair, seconded by Member
It appears.
Braham?
Yes.
Yes. Any matter arising? All right, if there is none, we will move to the next minutes, or we simply take collectively matters arising from the 2 minutes after we have confirmed the other minutes. So minutes of the meeting held on January 29. Page 1. If there is no correction to page 1, we go to page 2. So I am proposing that the line, the ultimate and penultimate lines of the paragraph commencing the chairman further commented that it seemed clear that we change because the decision to approve the reforms had to be made by the people, etc., to simply read because the bill passed by the parliament would have to be approved by the people. So the sentence would read, he stated that the administration considered it critically important for information. You can take out that was that for information presented to the public to be accurate and truthful. Full stop. The bill passed by Parliament, or the reform bill passed by Parliament, would have to be approved by the people. Member Sinclair, were you coming in on the page?
I didn't hear your query, Madam Chair.
I was asking, I thought I heard like you were coming in.
No, no,
Well,
no.
very well. So the paragraph commencing the chairman indicated there was a procedural regulation of the Constitution at Standing Order 75. So the chairman, I believe I reminded that the standing orders were regulations of the Constitution, and that Standing Order 75 1 required that, as far as possible, select committees should be so constituted as to ensure that the balance of parties in the House is reflected in the committee's composition. May I ask that the sentence just end at that national goals were being pursued and they should transcend composition of political parties in the parliament, that be deleted. It really adds nothing. The point is that these were national goals that were being pursued. It was not so much about who was winning, which party would win or lose. Okay? Madam Clerk, I'm going to ask that the sentence went on to say that context in which the goals were being pursued could not be wished away, that be rephrased, right? So the chairman emphasized that we cannot change the context in which the reform goals were being pursued. Or better yet, that we emphasize that we had to take account of the context in which the reform goals were being pursued and where we were in the life of the parliament. That's the issue of time frame. Not every point made has to be reported directly. You capture the essence of the point being made for the readers. And the point was that we can't wish away our context. And we are where we are in the life of the parliament. That's the time frame issue. And so context and time, the work had to continue. Again, I'm going to ask that that paragraph be revised, the paragraph that asserted that it was not true, that the government, the opposition lacked information. Right. So the government's approach to implementing the national goals being pursued in the bill, the government's approach was made clear from the start. She believed that the present disagreement had more to do with how the process was being led. The issue, the question of leadership of government, was one that was decided at elections. Who gets to lead government? That's what elections decide. I'm going to ask that that first sentence also be reviewed. The first sentence seemed to run 1, 2, 3, 4, 5, 6 lines. And I think the punctuation mark is missing between finalized and furthermore. We don't even know what signature page. All right. So the chairman indicated that an examination of the signature page of the Constitutional Reform Committee's report show that the members nominated by the leader of the opposition had not signed the report. It was said that they were instructed by the leader of the opposition not to do so, not to sign. Because the report contained matters that had not been agreed. Full stop. However, the decision-making modality of the committee was one of consensus. Full stop. Only matters on which consensus was reached were included in the report. Full stop. Then, furthermore, on the day when the report was signed, the matters were revised out of the report to ensure that only matters on which consensus was reached were included. Sentence which begins, she continued that the terms had been set out, the terms of reference for the Constitutional Reform Committee were set out and agreed to. You could agree to, full stop, then therefore the phased approach and the treatment of the final court in a subsequent phase and not come as a surprise. I'm sorry, my page was interrupted. Please remind me what page we were on. Madam Clerk, member?
Page 3.
Page?
3.
3, I see. Something interrupted the page 3. Thank you. Yeah, sorry, there's been a all right. So the chairman advised the committee that she was presenting this information because of the issues that had been raised by the leader of the opposition. And a request had been made through the opposition members, not just through the members. So the members of the committee requested his presence, and that request was conveyed through the opposition members. It was also conveyed by me at a meeting too. If there is no other correction to page 3, we go to page 4. Member Sinclair, please just take a look to see if what is attributed to you has captured it clearly. Ms. Cohen, going forward, please please shorten the sentences. I understand that we speak in long sentences and we have all kinds of modifying clauses. But when we reduce to writing, bear in mind that people have to read and we don't want to lose them with the long sentences. All of us need to, when we see how we speak reduced into writing, sometimes tell us that we need to modify our sentences short and clear. All right, if there is no other correction to page 4, we go to page 5. Presentation on systems of governance and accountability by the Ministry of Legal and Constitutional Affairs, Ms. Sharika Mills, Constitutional Reform Officer. Paragraph, the presidential system. If there is no correction to any of the paragraphs on page 5, we go to page 6, the parliamentary cabinet system. Just to add, the word is usually a prime minister. The effective head of government is usually a prime minister. And that has, should be had. Minutes are always reported in the past tense. All right. If there is no correction to page 6, we go to page 7. I think the word by is missing, described by Ms. Mills. The chairman highlighted the connection between the proposed system described by Ms. Mills. All right. Accountability mechanism, Mr. Philip Cross, Senior Constitutional Reform Officer. May I suggest that you substitute the word expounded with explained? If there is no correction or the correction to page 7, we go to page 8. Right, if there is no correction to page 8, we go to page 9. If there is no correction to page 9, we go to page 10. All right, will someone move for the confirmation of the minutes of the meeting of January 29 as corrected?
I so move, Madam Chair.
Thank you. Seconded by Senator Brahan?
Seconded.
Thank you. Any matter arising? All right, I just want to point out the importance of appreciating the system of accountability that is set out in the Constitution. All presentations made so far were intended to help members of the committee and members of the public gain a better understanding of the provisions in the Constitution related to accountability, to gain a better understanding of the parliamentary cabinet system in contrast to the executive presidential system. As the wider context in which the retention of the parliamentary cabinet system is being done. All right. Excuse me. All right. We can then move on to the matters for today. Madam Committee Clerk, may you please inform us? I'm sorry, I'm just having a little bit of a challenge navigating the various documents that I have on the screen. Just a moment, everyone. Right, so we are now on agenda item 7, discussion on the bill. All right, the discussion on the bill is to take place in the manner of looking at the actual clauses and also considering submissions made by members of the public on those clauses. I'm going to ask the clerk to inform for the record how many submissions we have received so far from members of the public.
Good morning, everyone. There have been 16 persons who have made submissions, persons and groups.
Sorry. I am hearing an echo.
Right.
Madam Clerk?
I'm sorry. Great, it's clear now. 16 persons and groups have made submissions.
16 persons and 16 groups?
No,
or
in all.
16
Groups and
submissions
persons.
from individuals and groups?
Individuals and groups.
Would you find it helpful for a matrix? So normally we do a matrix of the clauses and comments on the clause, but I know we also we can set out the comments on each clause in a matrix.
So, Madam, the staff of the Parliament, in particular the Parliamentary Research Section, will prepare the matrix.
All right.
And may I make a correction, please? It's not 16 submissions in all, it's 13.
13?
Yes, Madam.
Okay. And all members, the submissions have been sent to all members and including the supporting staff to the committee.
Yes, they have.
Very well. Senator members Sinclair and Braham, do you have any suggestion on how we may efficiently consider the submissions? Just to say that preliminarily, I'm of the view that not every submission needs to be accompanied by an actual presentation in the Parliament, that it would depend on what the submission is on and the extent of it, but certainly all submissions would be considered by the committee. Any view on that?
The challenge, Chairman, is once you decided that organization A will not appear and B will, it then opens a can of worms as to why we chose B as against A. And
True.
that is going to create some further public distraction.
Your suggestion, therefore?
I think Ms. Cohen said there were 30.
13.
Right. Submissions. I think that, no, I think that I'll have to look at them before I'll make any further thoughts at the moment.
Understood. Member Sinclair?
The submissions were sent to us by email. And I started, I think I got them yesterday.
Yeah.
And I started last night to just look through a few of them. I think there needs to be a screening process because I came across, I think, 2 that really did not address any of the issues in the bill that is before us. They spoke to just some other issues that the individual may be having in their particular community, but should not be. It doesn't impact the bill. It doesn't make any reference to what is contained in the bill. Those 2 I came across. So I believe that obviously there is some screening process, and the ones that are relevant, and if they need to be expanded on, those persons can be invited. But obviously, as committee members, we would have been given the opportunity to look at all of what has been submitted. But I have been to joint select committees that submissions have been made and persons have been specifically invited to go through their particular submission once there is relevance to it.
All right, so I'm hearing a number of things from what you have said, that submissions are speaking to wider issues than matters contained in the bill. And the purpose of the committee is to review the provisions of the bill. And so we would need to focus on submissions that relate to the provisions of the bill instead of going at large, as some persons have gone. Yes?
Yeah, that is my viewpoint.
Yes. I think I'm seeing Senator Golden Campbell.
I should have actually indicated to you when I started that Senator Golden Campbell is presented. She had apologized on her behalf that she would be a little late, but she's presented at the moment.
Yeah. Thank you, Member Sinclair. Senator Golden Campbell, we are exchanging some perspective on the most efficient and effective way to deal with the submissions received so far from members of the public. Need to remind everyone that the focus of the Joint Select Committee is to review the provisions of the bill. Some of the submissions go wider and are speaking to issues that will come in another phase. Naturally, if something is to be included in the bill, that can be considered, but we bear in mind that there has to be consensus and that matters for inclusion in a bill also have to begin at a policy consideration before they become legislation. And policies have to be agreed, and there is a process for that to be done.
Madam Chair, I would just say that quite often there are entities that deliver written submissions who don't intend to come to do oral submissions. So what we're looking at as 13 now could actually be less in terms of those who actually want to come and make a presentation. So we should probably bear that in mind as well. And then I would just say that in terms of the submissions that are delivered orally, that we just have some structures for how long people are going to speak. I mean, we don't need somebody to come to read their presentation to us, maybe just to highlight the issues. So just to create some timelines for those submissions that are delivered orally. I don't recall if we had done that in the initial meeting. We might have. We didn't? Okay. So yeah, just to give some timelines for the presentations so that we can get through them and just be directed to the main and salient points in the submissions.
Thank you. All right. So it's appearing that we will need some time as committee members and the supporting staff to go through the submissions for us to have an appreciation of the content of those submissions. And then we can decide, perhaps even in consultation with those who have submitted, who will come and the timelines to be given. But right now, I would say we could defer the timeline to be set and the decision to be taken on who would be presented until we have, as committee members, read the submissions ourselves. Yes? All right. I am proposing that we look at the provisions of the bill tidying up the citizen provisions of the Constitution today. And that would be as far as we go today, because on the next occasion, we would start going into the office of president, that is to replace the monarchy. So the provisions dealing with citizenship are not very long, and I would invite we start at page 7 of the bill, clause 7. Madam CPC, may I ask you to take us through clauses 7, 8, 9, and 10, please?
Clause 7, repeal and replacement of Section 8 of the Constitution. Section 8 of the Constitution is repealed and the following substituted therefore. 8, deprivation of citizenship. 1, no person who is a citizen of Jamaica by virtue of Section 3(1)(a) B, or C shall be deprived of Jamaican citizenship. 2, a person who is a citizen of Jamaica, other than by virtue of the provisions specified in subsection 1, may be deprived of Jamaican citizenship in accordance with a law made under section 10A. 3, a person who is aggrieved by the deprivation of that person's Jamaican citizenship may apply to the Supreme Court for redress. 4, the Supreme Court shall have original jurisdiction to hear and determine any application made under subsection 3, and any person aggrieved by any determination of the Supreme Court under this subsection may appeal therefrom to the Court of Appeal.
All right, just pause, please. Members, and in particular, Member Braham, just to direct your attention. So this section is preserving what is already in the Constitution about the acquisition of Jamaican citizenship by birth, descent, or marriage. And currently, the Constitution provides that if you acquire Jamaican citizenship by any of those three medium, you shall not be deprived of citizenship. So we are preserving what is already in the Constitution. These were amendments that were made in the 1990s, if I am recalling correctly. We do not now have set out clearly at the constitutional level a process. So the provision is empowering the Parliament to make a law to deal with the matter of deprivation of Jamaican citizenship. Ms. Wilkins, can you just indicate how the matter is currently dealt with?
Chair, the matter is dealt with in two sections now, Section 8 and Section 11. So this proposed redraft of Section 8 brings them together because Section 11 had dealt with deprivation and renunciation, and having regard to the fact that Section 8, by its marginal note and its content, deals with deprivation, it was determined that it would be better for all the provisions dealing with that be in one place.
Thank you. Members, any comment? Senator Braham, I'm particularly interested in your view on the right that is being granted to deal with the matter of deprivation by the Supreme Court, giving it original jurisdiction, and then an appeal from that to the Court of Appeal. Different jurisdictions deal with it differently. Should this be a matter how?
I think Senator Sinclair had a query there.
Okay.
Maybe since he may have had the original thought, I'll allow him to go ahead.
Okay.
And I thought that Senator Braham would have just provided answer in answering your query, Madam Chair. But I was just looking at what is the proposed 8.4, which says that the Supreme Court shall have the original jurisdiction to hear and determine an application. Any person aggrieved by any determination of the Supreme Court under this subsection may appeal therefrom to the Court of Appeal. Is that where the possibility of appeal ends, at the Court of Appeal? Or
So you are tapping into the issue that I am raising.
there, and
All
that's
right,
why I had said when I started that if Senator Braham had provided us with his comments, he would have been giving a response to your query, which would have answered the query that I raised with him quietly.
Senator Braham, how would the court interpret this provision?
It has not been interpreted, but I don't see why, on a matter of citizen, other matters, the provisions dealing with fundamental rights can go to the third tier. Citizenship is, to my mind, akin to fundamental rights, and I don't see why it should not. Why I don't understand the policy reason to prevent an appeal or to even cause a doubt as to whether there should be an appeal to the third tier in this type of situation. I think that it should be treated just as in the fundamental rights, Chairman. And then once I say that, maybe Ms. Wilkins or Ms. Grant may answer this as well. The first section 8, subsection 1, sorry, is tied to a piece of legislation, Citizenship Act. And I wondered, and I suspect that is a section that deals with citizenship by birth. Am I correct?
A is citizenship by birth, B, I think, by descent, and C, by marriage. If you look on the existing provisions of the Constitution, you would see, if you look at Chapter 2 currently, you would see Section 3. Section 3.1, Chapter 2 of the Constitution is headed Citizenship, and Section 3, subsection 1 says, a person may, in accordance with the provisions of this chapter, become a citizen of Jamaica by A, birth, B, descent, or C, registration as a citizen of Jamaica based on marriage to a citizen of Jamaica. 2, Parliament may make provisions for the acquisition of citizenship of Jamaica by persons who do not become citizens by virtue of the provisions of this chapter. So the chapter provides for 3 methods by which citizenship can be acquired, but it also empowers the Parliament to provide other avenues for citizenship to be acquired. And I think that's the naturalization process. If you live and work for a period of time, you can qualify. The law will set out those criteria. And then subsection 3 says, subject to subsection 1. Subsection 1 shall not affect the right of any person who, before the 26th day of March 1999, was entitled to Jamaican citizenship by virtue of any provisions of the Constitution in force that date.
Did we consider, Chairman, and I know this is a carryover from the previous provision, so we have 3 categories of citizenship that once you get it, you cannot lose it. Whether or not there could be any circumstances where, say by marriage or birth, descent and so on, that you could lose the citizenship. And I'm not saying that you should. I just wondered whether any thought has been given to a circumstance that it may be in the interest of the country or anything like that, or it is just a matter that the policy is that we will guarantee citizenship for all these 3 categories regardless. And I'm emphasizing that at this stage I am not recommending that anybody lose their citizenship.
So the policy
I'm asking
decision
a question at the moment.
Yes, yes. And these are clarifying questions, of course. So the policy position was to preserve the existing methods by which citizenship may be acquired. But as we were reading the section, I believe that something else needs to be provided for. In our consultations with members of the public, and in particular, on occasions when I had consultations with the Jamaicans living abroad, facilitated through our embassy in Washington and our consulate, the question was raised about the need for clarity on the requirements for citizenship by descent. And I'm now thinking that maybe this provision or the other provision may also, subsection 2 of the proposed 8 should not only speak to a process, any other process, well, it says that may be deprived of citizenship, not just the deprivation issue, but the empowerment of Parliament to make the laws in respect of the acquisition by descent. I think birth right now is automatic. I am not sure how the marriage works, but my understanding from the research is that you would not be deprived of your citizenship if you have married a Jamaican citizen and that marriage has dissolved. I think a number of rights issues would arise and what is fair in those circumstances. But I think there is still a gap in the law around the nationality issue. And this is separate and apart from any question about whether you can achieve or acquire Jamaican citizenship by descent to any degree. Some jurisdiction restricted to a 5th generation or a 6th generation. We have addressed the issue of nationality by descent for the president to no further than a grandparent. But we know culturally issues around allowing generations of persons born abroad to Jamaicans to participate in our sports. We know that we recruit from the diaspora people for the national football team, men and women, and from time to time, persons represent Jamaica in the Olympics and the the World Championships, who are descendants of Jamaicans. But what was clear to us in the consultation process is the need for clarity around acquisition by descent, even if no decision has been taken to narrow it. But you spoke about the need to look at it, any limit in the interest of the nation. Specific rights and responsibility, rights are guaranteed and responsibilities placed on the state in respect of citizens. And it's a discussion that is worth having. We are a rare people. Should our citizenship be so open that anyone can acquire it? What limits, if any, should be placed on it? That's one set. The other matter that was raised, and I think we should just put aside that for the time being and come back to the issue of jurisdiction. What I gather you're saying, Senators Sinclair and Braham, that doubt may arise and doubt has arisen in your minds on what is the true intent of the proposed Section 8, subsection 4, about whether an appeal, a further appeal can lie after an appeal to the Court of Appeal. May I invite the technocrats to assist in answering between Ms. Grant and Ms. Wilkins?
Before Ms. Grant or Wilkins answer, if it was that we had simply left it without saying that there was a right to appeal, I believe it probably, under the sections that deals with appeal to the Privy Council, would have been automatically assumed, having regard to the fact that it's a constitutional issue. That's my recollection. So when you put it in and say that appeal is to the Court of Appeal, I think it probably would be interpreted to limit it only to the Court of Appeal. And then in terms of the citizenship by birth, of course, at the moment, we don't have a lot of people running us down to be born in Jamaica.
Not yet.
But, you know, I do query this sort of, and I'm trying to be very careful, I do query it if the state should have no way, if there's an abuse, the state should have no way of doing anything about it. I think deserves at least a query.
Like I said, the section is preserving something, but the issue was raised in the CRC, and certainly it has been raised elsewhere. We're not legislating only for today, and we know that our circumstances are improving, and it is our hope that we will realize our goal of making Jamaica the desired place to live, work, raise family, and even retire. But it doesn't mean you have to retire with citizenship. As long as you meet residential requirements and you make your contribution to the society. I have a far more conservative view on this matter, but let me hear other members, and then we can invite the response from technical team.
MP Morrison has arrived, so that you may be able to ask her a few questions, Chairman.
So the question is, should the state be empowered to deprive citizenship acquired by either birth, descent, or marriage? Were you speaking to all three categories, Senator Braham?
Minister?
Were you speaking to all three categories, birth, descent, and marriage? Because right now, the policy is that you are not, the legislative, the constitutional provision is that you are not to be deprived, but you yourself can renounce. So it is prohibiting the state from taking action to deprive you of the citizenship that is acquired by any of the three means. But that does not mean you yourself may not divest yourself of the citizenship. And that is where renunciation now comes in, which is the next clause. Maybe it may be useful to just go through clause 8.
But before you do that, though, I would just say, let us take citizenship by birth. In the context of Jamaica, would it be appropriate that at least one of the parents would have been a citizen in any of the categories mentioned? That's one. That is to say, let's use the mother, would have been a Jamaican by birth, descent, or marriage. Or do we want it regardless? You're passing by, it just happened. That's one. And the question is it possible that somebody who's a citizen, not by birth, that you may, because of national security, I don't know. It may well be easier to leave it, but I think that these are thoughts, and I just said it's a thought I'm raising, and I just wondered. But maybe we need not detain ourselves on it.
Well, you may recall that we grappled with the issue when we were looking at the the citizenship criteria for president. And the view was expressed in the committee that you may have someone who happens to be born in Jamaica with no ancestral connection to Jamaica, acquiring Jamaican citizenship. And then you have someone who happens to be born outside of Jamaica, who is deeply rooted in Jamaica, Jamaican parents, grandparents, great grandparents, etc. But by virtue of being born outside of Jamaica, they would not have been a Jamaican by birth. And so when we looked at the migratory pattern of our people, we decided that for this president, we would propose Jamaican citizenship by birth and descent, but we limit the descent to at least the third generation, and that was to ensure a certain level of proximity and closeness to Jamaica. I'm always of the view that since the Constitution is your highest law and it sets the limits and the parameters for other laws, because you can't pass a law that is wider than the provision of the Constitution. The Constitution is the broadest and everything else goes under. In the same way that regulations can't be wider than the Principal Act. It is always better to reserve power to address matters that may not arise immediately, but could arise in the future. So I don't know if we want to just say, once you acquire it, that's it. Because anything else, in order to make a change, would have to require a change in the Constitution itself. Ms. Wilkins? Before Ms. Grant comes in.
Yes, Chair. No, I'm thinking, Minister, that the Ministry of National Security, we're aware that this is the Jamaica Nationality Act, and these issues are issues that are actively being considered by that ministry with a view to proposing their reform. And perhaps it would be useful if the ministry is asked to share their thoughts on this matter, because there are several issues to do with nationality, and perhaps it would be good to hear them while we are considering this part of the bill. That's my view, Chair.
Yes. We know that all of the legislation relating to nationality, citizenship, immigration are now under review. But again, just for members of the public, it's the Constitution that sets the limits, sets the framework for the other laws to come and the provisions. And I think if no restriction is allowed or the Parliament is not empowered to restrict, then the way it would be interpreted is that it stands at large. All right. Would the committee make a decision to invite specifically the Ministry of National Security to provide comments on these clauses of the bill? It would be clause 7, 8, 9, and 10. Some of that was done, but we could go for more detail. Is that a decision that the committee is prepared to take today so that a directive can be given to the clerk to send the communication out?
Yes, Madam Chair. And that was with consultation with other members.
Very well. So let the records show that the committee has taken a decision to invite the Ministry of National Security, which has subject matter responsibility for citizenship, to assist us by making comments or by submitting on the provisions here. clauses 7, 8, 9, and 10. And of course, in the context of Chapter 2 of the Constitution, the existing Chapter 2 on citizenship. When we were making the decision on these provisions, we did take into account the work being done by the Ministry of National Security. But let me just say something to members of the public who are watching. It's very important for you to understand that the work of government is divided across ministries, agencies, and departments. Some people may be of the view that it is just government. So they sometimes believe that decisions are taken in one place. Not so. Even though the cabinet ultimately takes the policy decision, the work and details on subject matters are done in the respective ministries with their departments and agencies. And at a cabinet level, you do not always have the details and administrative details of how things are working, unless the matter is specifically presented for that kind of consideration. Work is divided and work is done by various officials. I have heard some criticisms levied, including coming from parliamentarians, which would give the impression that one part of government should automatically know what is happening in another part of government. Couldn't be farther from the truth. Government is not a one-man show. But we have to come back to the issue of whether doubt has arisen on the true intention of Clause 8.4 in respect of where an appeal lies in the event of a dispute around deprivation of citizenship. So is a provision as drafted limiting appeal to the Court of Appeal? This is a live question. May I just ask if members are so minded that we ask the CPC to take us through clauses 8, 9, and 10, and then we come back to the wider discussion. Yes? All right, if there is no dissent, Madam CPC.
Clause 8, repeal and replacement of sections 9 and 10 of the Constitution. Sections 9 and 10 of the Constitution are repealed and the following substituted therefore. 9, renunciation of citizenship. A person who is a citizen of Jamaica may renounce that citizenship in accordance with the provisions of a law specifying the procedure by which Jamaican citizenship may be renounced. 10, powers of Parliament relating to citizenship. Parliament may make provision, A, prescribing the grounds on which and the procedure by which a person who is a citizen of Jamaica, other than by virtue of Section 3, 1A, B, or C, may be deprived of Jamaican citizenship. B, for the renunciation by any person of that person's Jamaican citizenship. C, subject to the provisions of this chapter, prescribing the grounds on which and the procedure by which a person may become a citizen of Jamaica by descent. 9, repeal and replacement of Section 11 of the Constitution and transitional provision. 1, Section 11 of the Constitution is repealed and the following substituted therefore. 11, powers of Parliament relating to recognition of participation in certain state groups. Parliament may make provision in respect of the countries that are members of A, the Commonwealth, and Jamaica's participation in the Commonwealth, B, the Caribbean community, and Jamaica's participation in the Caribbean community. 2,
Unless other provision is made pursuant to Section 11 of the Constitution, as amended by this section, the countries mentioned in Section 3 of the Jamaican Nationality Act shall be treated as members of the Commonwealth. 10. Amendment of Section 12 of the Constitution. Section 12(1) of the Constitution is amended by A. Deleting the definition of alien and substituting therefore the following. Alien means a person who is not a citizen of Jamaica. And B. Deleting the definition of foreign country and substituting therefore the following. Foreign country means a country other than Jamaica.
All right. So let's deal with the easier provision by way of explanation. Currently, an alien is a person who, currently an alien means a person who is not a Commonwealth citizen, a British protected person, or a citizen of the Republic of Ireland. That's the current meaning of alien in our Constitution. And those are persons that are connected to the British Empire or the former British Empire. Now we're saying that if you're not a Jamaican, you will be regarded as an alien. Also, currently a foreign country means a country other than the Republic of Ireland that is not a part of the Commonwealth. And we're now saying that any country other than Jamaica would be regarded as a foreign country to Jamaica. That's part of the consequence of exiting the realm country. And for those members of the public who are watching, by realm country, I mean countries in the Commonwealth that have the British monarch as head of state. So the Commonwealth has a subcategory of Commonwealth realm countries, and those are the countries that have the monarch as head of state. The wider Commonwealth has other arrangements in respect of the head of state. Any comments from members in that regard on the proposed amendments to Section 12(1)?
I don't, safe to say that it would make other sections, particularly whether you're entitled to be a member of Parliament and so on, much easier to interpret. Then I don't have any other comment.
Yes, but those provisions are being revised to take this into account. So, we have already stated going forward, the citizenship criterion for membership to our parliament is Jamaican, not Commonwealth citizenship. And so the Ministry of Foreign Affairs will truly be a Ministry of Foreign Affairs, because with this definition, the other countries are foreign countries. We had also pointed out that for the first time, the Caribbean community and Jamaica's participation in it is finding its way in our Constitution. The Caribbean Community Caricom was established by the Treaty of Chaguaramas, and the treaty was revised, which created the Caribbean single market and supposed to be single economy. That work is not yet done, but we have the single market. And it was pursuant to the Caribbean single market that the Caribbean Court of Justice was established. Well, let me start again. It was pursuant to the revised Treaty of Chaguaramas that the agreement to establish the Caribbean Court was made, and it has its own framework. And Jamaica is a member of the Caribbean Court of Justice in its original jurisdiction dealing with Caribbean community matters, Caricom matters. Once you have a regional treaty and a regional body and matters arise from that, it makes sense to have a court dealing with those matters. And that is what the Caribbean Court of Justice deals with. But it also has the other jurisdiction, which is the appellate jurisdiction, where the opposition is saying that we should move to use that appellate jurisdiction. And the government is saying that when that is a decision that will have to be considered, but it is to be considered in the wider context of the administration of justice and which final appellate court would be best for Jamaica.
The reference to Caricom and Commonwealth. Now that we are clarifying the provisions so that Commonwealth, is not that significant insofar as citizenship requirement and so forth. Do we really need to be referring to either Caricom or the Commonwealth in our Constitution? Does that mean we should refer to the United Nations in it and other international body of which we are a part? One day, in the next 100 years, Caricom may be replaced by something else. Why is it absolutely necessary for either public international entities to be mentioned? I'm not saying they're not important, but do they need to be mentioned in the Constitution?
I am just looking back on the recommendation of the Constitutional Reform Committee on the matter. So, reform of the Parliament, the related recommendation is set out at paragraph 6.18 of the report of the Constitutional Reform Committee, this report. And it said there that the CRC is of the view that the Constitution is not the appropriate place for dealing with the Commonwealth citizenship. The CRC therefore recommends that current references to Commonwealth citizens should be removed and that status should be dealt with by ordinary legislation. Just to go back, in considering this matter, it was done in the context of basic questions. One, whether the entitlement of Commonwealth as broadly defined should remain. I'm seeing a typo there. It should be the entitlement of Commonwealth citizens. Whether Jamaicans living abroad with United States citizenship or citizenship of any other foreign country should be barred from membership in the Parliament. The type of citizenship qualification that should be required to serve in the Jamaican Parliament, and whether Commonwealth citizens who are not Jamaicans should continue to qualify for membership in the Parliament. On the matter of the Commonwealth citizenship, the CRC took into account that the Commonwealth of Nations is a free association of sovereign states comprising the United Kingdom and a number of countries, including its former colonies. These states have chosen to establish or maintain ties of friendship and practical cooperation, and acknowledge the British monarch as the symbolic head of the Commonwealth of Nations. It was specifically noted that since 1949, independent countries from Africa, the Americas, Asia, Europe, and the Pacific have joined the Commonwealth. The last 4 countries to have joined, Mozambique, Rwanda, Gabon, and Togo, have no historical ties to the British Empire. In today's context, relationships within the Commonwealth have evolved with reduced reference to the monarch. As just reminding of the context in which the conversation and the discussion took place in the CRC.
Chairman,
yes.
my question, well, maybe it's not a question, but the issue, we have the citizenship or the certain requirements for membership in certain entities will no longer be tied to the Commonwealth and Commonwealth relationship. If that is the case, Commonwealth as a definition or otherwise would not be necessary for our Constitution. It would be just like any other international body. Similarly, Caricom, I'm not saying they're not important, but they could be dealt with by normal legislation, and then there would be no overriding need to have a reference to either Commonwealth or Caricom in the Constitution. That's all I'm saying. But there you have it. Because there are other international agencies of which we are a part, and they don't get a mention.
Yeah.
And next year there may be another one, the Preamble's international body, that may become important. Anyhow.
It's a valid point, Member Braham. It's a valid point. Let me just, any other member has any comment or question on this provision?
And just, I agree with the comments made by Senator Braham, Madam Chair, with nothing further to add to it.
Yes. Thank you, Senator Sinclair. Member Goldin? Campbell? Member Morrison?
Sorry, Chair. I was having a little sidebar. I fully endorse Senator Braham's comments, but I was also trying to see where the Constitutional Reform Committee had a discussion about the inclusion of Caricom, and I wasn't finding that.
Well, this is a matter that was approved for inclusion. Let me see. So everything that is in the bill was dealt with. My curiosity is a little different. So these are really tidying up provisions. The context was that now that we're moving away from the inherited arrangements, we would take into account matters that are closer to home within the Caribbean community.
Yeah, but
the question is, do we need to provide for it at all? Because currently we have a provision in relation to the Commonwealth, and we really were taking it down to say that it would be done by way of ordinary legislation. If you look at Section 9 of the Constitution now, Section 9(3), save as may be otherwise provided by Parliament. The countries to which this section applies are the United Kingdom and colonies, Canada, Australia, New Zealand, India, Pakistan, Ceylon, Ghana, the Federation of Malaya, the Federation of Nigeria, the Republic of Cyprus, Sierra Leone, Tanganyika, that's now Tanzania, the Federation of Rhodesia, that's now Zimbabwe, and Nyasaland and the state of Singapore. So even the names of these have changed. So we really were just dealing with what is contained here in respect of Commonwealth citizenship and the countries from which those citizens came. And the Constitution had said, unless Parliament makes other provision, these are they. We were taking out all of these and simply to say that Parliament may make provision in respect of the countries that are members of the Commonwealth. Because Jamaica is not exiting the Commonwealth in its own arrangement. It's just that the Commonwealth is not featuring as prominently by way of its citizens, other than Jamaican citizens having entitlements to sit in our parliament.
Chair, just to say that there was, I think the report reflects a recommendation that it provision be made at paragraph 9.1.2.
Yes.
And that all that it will be doing is making it clear that the Parliament is empowered to make legislation. It's not making any other provision for it, save that it is ensuring that Parliament's jurisdiction to make legislation about it is provided.
Yes.
Ms. Wilkins has raised an important point. 9.1.2. The CRC also recommends that Parliament be empowered to confer privileges on or make special provision for Caricom citizens by way of ordinary legislation. So the section that I was reading here, do we have something to that effect in
Section 9.
Section 9?
Well, the provision is stated generally that Parliament may make provision in respect of the countries and Jamaica's participation in these two groups.
So
more broadly. But the real question,
11,
Senator Braham, is
11.
the power of Parliament fettered if there is no provision like this? Because Parliament has the power to pass laws, generally.
Maybe it is, maybe, but the new 11 doesn't seem to be contemplating citizenship, if that's what it is the intent. It may be fettered because you have earlier, say, the categories of persons who can become citizens. So if you wanted to confer citizenship on Caricom members, for example, you may not be able to do it. But if 11 is intended to deal with the question of citizenship, then it may not be sufficient.
And just a minute.
When I say 11, I mean 9. 9.
Oh man, we have a provision which empowers the Parliament to pass laws in respect of persons who may acquire citizenship by other means. So,
I'm a little confused. If I could just direct this in the meantime, Madam Chair, to the Parliamentary Council. This clause 9 in the bill is repealing section 11 of the Constitution. And section 11 is the power of Parliament to prescribe the grounds on which a person can be deprived of citizenship, and the power of Parliament to deal with renunciation of Jamaican citizens. So that in repealing that, we are replacing it with the power of Parliament relating to the recognition of participation in certain state groups. That's what we're doing?
All right, just to say that the sections are being utilized a little differently. The citizenship provisions span, if you look on Chapter 2 of the Constitution now, you see Chapter 2 commences with Section 3. Chapter 2 of the Constitution is entitled Citizenship. You have Section 3, which deals with the acquisition of Jamaican citizenship, and those amendments were taken in 1999. Then you have a new 3A. These were 93 amendments, persons entitled to Jamaican citizenship. Then you have a 3B, a 1999 amendment, persons born in Jamaica becoming citizens of Jamaica on August 6, 1962, in the case of persons born before that date, and then after that on the date of their birth. And then you have matters related to how you treat persons born on a ship or aircraft registered in Jamaica or belonging to the government of Jamaica. We have a
while we're waiting on Chair to come back in, CPC, the provisions that are being repealed under the current Section 11 are provided for in what clause of the bill? 8.
8, yes. It's just a reordering. It's
Right,
not that
okay,
they have been repealed
well.
and not replaced.
Very well, okay. Yeah, I too agree with Senator Braham about the need to even name the Commonwealth or name the Caribbean community. I never thought that I would ever see a day that the UK would have left the EU, but then they did. And you wonder now if they're, well, I guess they don't have a written constitution, so it wouldn't apply. But yes, I think perhaps that clause ought to be written in a more general way to give Parliament the power to make provisions in respect of countries that are members of, I don't know what you'd call it, that's to be figured out. Huh?
It's general. If you look at the marginal note, you will see that it is quite general. So, I mean, if that recommendation is taken on, the provision itself could be written in similarly general terms.
Yeah, you're right. You don't need it at all, Senator Braham. You're quite right. Yeah, I agree with that. Okay. I'm landing right there.